Good afternoon, everyone, and thank you for joining us for the Adult Drug Court Discretionary Grant Program FY 2018 Competitive Grant Announcement webinar. My name is Preeti Menon, and I am the Senior Associate Director at the Justice Programs Office, a center within American University's School of Public Affairs. Justice Programs Office, or JPO, is also home to the National Drug Court Resource Center, which is part of BJA's Drug Court Initiative. Now, many of you may have visited the Resource Center online at ndcrc.org. The website has a section on grant solicitation resources, and a recording of this webinar will be available there by the end of the week or sometime next week. I would like to introduce Gregory Torain, who's the BJA Policy Advisor for the Adult Drug Court Discretionary Grant Program. And prior to joining BJA, Greg was the Substance Abuse and Mental Health Service Administration in multiple roles, including as a Public Health Advisor for SAMHSA, SAMHSA's Center for Substance Abuse and Treatment, working with specialty court grantees. During today's webinar, Greg will provide an overview of the recently released Adult Drug Court Discretionary Grant Program Competitive Solicitation. And as you listen to the presentation, please note down your questions in the Q&A screen on the bottom right of your screen. We will collect the questions and answer them at the end. We will also compile these questions and make them available in a PDF document in the Grant Solicitation Resource page on ndcrc.org. And before we start, I want to go over how the webinar will look or work today. All attendees are currently muted. If you have a question during the webinar, please submit it again on the Q&A section. Today's webinar is being live captioned. To access this feature, just click on the multimedia viewer icon on the top right of your screen. And we're also recording the webinar. Again, it's going to be on ndcrc.org. It will be posted on Justice Programs Office YouTube channel as well. And lastly, I would like to mention that before you log off, please complete the webinar evaluation at the end. Your comments provide valuable feedback, which allow us to improve our future webinars. Also, if there are questions that we do not get to during the session, or you have additional questions, you may write them out in the notes section of the evaluation form, and we will respond to you as soon as the webinar is done. And with that, Greg, you have the floor. I'm going to pass the control of the PowerPoint to you.
Okay, thank you. Thank you, Preeti. Hello, everyone, and welcome to this year's FY18 Adult Drug Court Discretionary Grant Solicitation webinar. We're really excited to have you on. We're looking to hopefully get a lot of applications come in. This year, BJA, through the President's budget, received an increase in our budget. So we're looking to definitely make a lot of awards this year. So we're really excited about that and really look forward to a lot of great applications coming in this year. Again, like Preeti said, my name is Gregory Torain. I am the Policy Advisor for the Drug Court Program. I've been with BJA for over a year. Prior to me being here, you guys probably, if you've worked with our BJA grants, worked with Tim Jeffries, who's done an awesome job in past years. So hopefully I'll get a chance to go through a lot of the solicitation and some of the new adjustments to the solicitation, and hopefully have a lot of great questions you can ask. And again, like Preeti mentioned, we may not be able to get through all the questions in this webinar, but you see my email address there, as well as we'll have information on the Preeti mentioned on the website or on the NRDC website, where you would be able to see some of the questions and be able to, again, see this webinar online. Okay, some of the things we're going to go over today, we're going to talk about the new funding for drug courts. I mentioned that we got an increase, so I'll be talking a little bit about that. We'll also talk about the goals and the administration priorities. It's good to really focus on what those priorities are, because a lot of our the decision making and what we look to see come in terms of the applications need to be consistent with the administration's priorities. Also, we'll talk about the eligibility requirements, going over funding categories. Many of you are familiar with the BJA grant. We still have both the implementation, enhancement, and statewide categories. And then we'll go over the application sections. And then one of the sections that was put together by the program managers in terms of what they see when awards come in, some of the top 12 applicant tips to prevent issues or delays when funding is awarded. So if we're so lucky to be funded when you're completing your application, make sure you pay attention to these tips. And then lastly, some of the grant solicitation resources at the end that Preeti also mentioned on the NDCRC website. So the annual drug court funding history, as you can see over the past couple of years, going from 2015 to 2018, what our funding has been like. As you can see, drug courts are very successful and think highly of, and we've continues to get money for our drug courts to support the efforts that you all do in your local communities and your states. So you can see this last appropriation went to $95 million. It was a $45 million increase. So again, really impress on you to complete an application, write a really well application, and we hope to get as many as we can because we're looking to make a number of more awards than we made last year as well. So what does that look like? What does that $95 million look like? So for adult drug court, it's broken down in two, the adult drug court discretionary grant program broken down in two sections, one being the adult drug court and the other being for veterans treatment court. For adult drug courts, the funding level is at $75 million, and for VTCs, our veteran treatment courts is $20 million. As you know, last year for our adult drug court, we were funded for $43 million, so now it's $75 million. And for veteran treatment courts, we had funding for $7 million, now it's up to $20 million. And where does that money go? So it goes in a lot of our training and technical assistance. Looking at bullet 2, the main part of that money also goes into the appropriation for grant awards. As you can see, we're projected to award up to 96 awards. Last year, we awarded 53, so that's close to doubling what we funded last year. And again, I impress on you to complete an application and do the best you can and make sure that they're consistent with the priorities and all the goals and objectives related to the grant. Moving on, so the goals. The overall goal of the grant really is for BJA to support local drug courts and state coordinators with the various resources from our TTA providers, from the great work that our program managers do once you're awarded to work with you, as well as all of our other resources to be able to support the work you do to be more successful in supporting your communities. And we really want to make sure that with that support through our TA that you're getting the most current evidence-based practice and principles and services to be able to enhance your current drug court. So I mentioned earlier some of the administration's priorities. One, we'll make sure you're administering comprehensive strategies that address the opioid crisis and prevent overdose. This is a huge one because, I don't know if you know, but one of the things with the drug court funding, it's funded under the President's budget under the opioid crisis. So this is one of the President's strategies to address the opioid crisis. And we'll get further into that and what that means for if you're a drug court or a state that opioids isn't your target drug or your main drug. We'll get into that a little later on. Also, support law enforcement and other criminal justice partners. Yes?
You're going in and out a little.
Oh, am I? Okay, it must be this phone. All right. All right, I'll start back with the administration priorities. The first priority is administer. Let me know if I keep going in and out. I don't know if it's this phone.
Sure.
Okay. So these are pretty much the priorities. You want to make sure that you're partnering with your local law enforcement and indicating that within the solicitation on how you plan to work with them. Obviously, always promoting evidence-based strategies. And if you're a VTC, a veteran treatment court, ensuring that veterans have access to services post-traumatic stress disorder, and prioritizing funding in rural and high-poverty communities. Okay, so the application was released last Monday, April 30th, and it closes June 5th, 2018. So who may be able to apply? It's adult drug courts, DUI and DWI courts, co-occurring courts, tribal illness and wellness courts, and veteran treatment courts, both type A that service violent offenders as well as non-violent offenders type B. So within the application, you could apply for either A or B, depending on what population you're looking to serve. Okay. So it's broken down in 3 categories that many of you may already know: the implementation, enhancement, and statewide. And I won't go too far into each one of these because I know you all have a solicitation, but for implementation, that is categories for potential applicants who are applying, who haven't had a drug court started but looking to start a drug court. So you would be looking to use that or go under that, apply under implementation, looking to start or implement a drug court. And then with enhancement, if you've been a drug court operated at least 1 year, and you're looking at enhancing your program, whether it's you're looking to increase the number or capacity of individuals in your drug court, or you're looking to enhance your services. And then statewide is specifically for states to apply, and I'll go further into what's allowable with each of the 3. So an applicant currently receiving BJA drug court funding is not eligible to receive additional BJA drug court funding if it is applying for a similar focus, i.e. target population or type of court, as it is current drug court. The applicant must demonstrate in a new application that it is funding new focus area. So this was put in, it's not a new thing, but it was put in for people to be able to see for this year. What this pretty much means is you can't have 2 active BJA drug court grants with the same focus or target population. You can't fund 2 veteran treatment courts, the same court with the same amount of funding. So if you currently have a BJA grant and it ends in December or October of this year, this grant is looked to start in January 2019. Will be the start date. So you would be able to apply. So again, it's so that you wouldn't have you wouldn't be able to have 2 grants BJA with the same focus area, and they're both being active. Next slide. So eligibility for category 1 and 2, eligible applicants have to be either state or local courts, counties and units of local government, and federally recognized tribes. In category 3 is for statewide, you have to be a state agency. It's only limited to state agencies. Next slide. So some of the differences that we made from last year to this year, you'll notice for implementation, you now can request up to $500,000. The period of performance has changed from 36 months to 48 months, and the start date is now January 1st. This funding is for jurisdictions that have not completed the planning process, and operational pilot programs may apply. Some of the allowable uses of these funds for your general court operations and services, participant supervision, management, and services, provision of coordination of recovery support services, that being housing, placement assistance, or job training. Enhancement 2, similar to category 1, we increased the amount that you could apply up to is $500,000. Again, 48 months from the 36 months last year, and the start date again January 1st, 2019. And these are for, like I mentioned earlier, fully operational drug courts. And the use of funds, you can scale up your program capacity and enhance court operations, and pretty much in general improve the quality of your program, whether you need to develop a management information system or what have you. Am I still breaking up?
you're doing fine.
Okay, good, thanks. Okay, statewide. So we also increased it statewide as well. So as you all know, or as you read the solicitation, statewide has two separate subcategories, Category A and Category B. Category A is now, let's see, 500,000. That used to be 300,000 last year in a previous solicitation. Now it's 500,000, and then subcategory B is now 1.5 million, where it was 1.2 million last year. So if you apply for both, you can apply up to 2.2 million, or 2 million for if you apply for subcategories A and B. The period of performance is 48 months, and again, it starts at the same time, in January 1st. We encourage you to, if you are looking to apply, or a state looking to apply for A and B, but you can't apply for them separately as well. And I'll get into the allowables next. So subcategory A is really for states applying to improve or enhance their drug court consistent with the evidence-based principles of the basic practice and standards. Also, in using subcategory A, if you apply just under that one, you use that funding is really just for, or that 500,000 is for state training, improving drug court functioning statewide, really enhancing the work you do on a state level with that funding, whether it's again, statewide training or what have you. Subcategory B is a little different. That's really to support drug courts within your local jurisdiction or regional jurisdiction. And important thing to note is that all federal funds under subcategory B, which is at 1.5 million, must be passed through the drug courts within your state. No funds may be retained for direct cost or for administrative purposes. Okay, a couple things to note for this solicitation. Activities funded should have a clear connection to to include activities related to criminal justice and enhancing program capacity. Requests for funds with a primary focus only on treatment resources, post-release services, or support medical service are not subject of the solicitation. And what this pretty much means is if you're applying, we want you to remain focused on what the goals and objectives of drug courts that are indicated in the solicitation on page 7, and as well as it should be, your application should be consistent with what's allowable, which I indicated in each of the categories. So that's really what that means. We really want to stay away from an applicant applying 100% or using $500,000 over the year or over that period of performance, only focusing on medical services. So we want, so that's why that's there. Funding on the solicitation should primarily be used to support the overall goals and objectives, is what I just mentioned a second ago. And any entity applying to either Category 1 or Category 2 enhancement on behalf of a drug court must complete an attached fiscal agent MOU, and this has also been included this year and added. So I know a number of questions may come as it relates to that. So this really is a focusing on. So if you're a state agent, this really applies to state and local entities. So if you're an example would be if you're applying, you're a county agency, or you're the county applying for a drug court grant in collaboration with the drug court, you would need to do a memorandum of understanding. We want to make sure that when you're applying for the grant that there's, we can see what the communication and what the partnership would look like or should look like when you receive the award. So that's why that's in there and added. Okay, moving on to cost associated with recovery support services. This is new as well. Applicants are encouraged to provide recovery support services to clients in their drug court programs. No more than 25% of your budget of the overall $500,000 should be used for one particular recovery support service over the life of the grant. Grantees requesting to increase the limit beyond 25% must request prior approval. and provide justification. So if once you apply, you receive the award, and you feel that you need to increase that amount, then you would be able to do that working with your program manager. Within the application, on the last or third to the last page, or page 49, there's examples and definitions of recovery support services. So you'll be able to see what those are. Okay. Prior considerations, similar to the past, prior consideration for those that are applying for Category 1 or implementation. If you participate in BJA's Drug Court Planning Initiative, then you would be given priority consideration for your application. There's more information related to the Drug Court Planning Initiative that I'll get into later. What's new is that we also included the NHTSA Foundation, DWA Court Foundational Training, as well as a priority consideration for those DWI and DUI courts looking to start a DUI or DWI courts. You'll get that same priority consideration for those who participated in that training prior to the application process. BJA also will provide or give priority consideration to applicants that in the project design section of the application propose designs and strategies that adhere to the 10 key components and identify which state-specific NADCB best practices they are seeking to implement. Some of the things that are also required, one I mentioned earlier, that an applicant must demonstrate that and I'll read this directly because it's important. The applicant must demonstrate that the drug court understands and agrees that to the extent that substance abuse treatment and related services are funded by this award, they will include treatment and services to address opioid abuse reduction. BJA has clarified with the Office of General Counsel that funding is not limited to opioid abuse reduction, and applicants may focus on serving offenders with addiction to other drugs and alcohol in addition to addressing opioid abuse reduction. So what that means is, like I mentioned earlier, obviously this money comes throughout the President's budget under the opioid crisis. So when you're applying, you have to indicate a strategy for addressing or providing services for individuals who come in contact with your drug court program who have opioid abuse. Again, if you're in a state or a local drug court program area where opioid is not an issue, you still have to indicate in your application how you plan on addressing that if you do have individuals that come with your drug court program with the opioid abuse issue. But
you were going in and out again.
Okay. Yeah, so what this requirement pretty much means is that you still have to, within your application, if this is not your target population, you still have, yeah.
I'm sorry, you're going in and out again.
Yeah, I'm sorry, I don't know what to do except for call back in on a different phone.
Okay, let's try, go ahead.
Okay, so I'll go to the next requirement, and this hasn't pretty much changed. This requirement just means that the drug court is trying to get funding, so cannot deny any eligible client access to the program for FDA-approved medications. So that was in our past solicitation, and that's not primarily new. Okay. So I'll be going over some of the application sections. You got the federal application, the SF 424. We're going over the project abstract, project narrative, the budget. As you can see, some of these are required to be in a document. So the program narrative and the budget detailed worksheet and budget narrative is required along with the time task plan. So if you do not have any of those in your application gets screened out in the initial stage. So please be sure to make sure you have that information. Indirect cost rate, tribal authorization resolution, those are all the forms that we'll go over. So additional attachments, like I mentioned earlier, the time task plan is a requirement. MOU signed by all team members or a designated agency representative. This is recommended. What's new is in the past it was that you had to have it signed by all staff, all team members, but we included that it can be a designated agency representative can sign off as well. Also new, and I talked about a little bit earlier, the fiscal agent MOU. The State Substance Abuse Agency Director or Designee letter is recommended to have in there. Chief Justice, State Court Administrator or Designee letter is recommended. Policy and Procedures Manual, disclosure, pending applications, research and evaluation, and this pretty much all the attachments that you need to be aware of to make sure that they're applicable to you. So in the abstract is important. Funding category, you need to indicate whether it's an implementation, statewide, or enhancement. Again, if it's rural, urban, suburban, or rural. Just down the line, you need the type of drug court it is. So you need to have each one of these in your abstract. These are the things that we'll be looking at as we're reviewing it. Okay. So this year for the program narrative, we didn't change any of the percentages for each of the categories, so they stay pretty much the same. For a statement of problem, category 1, it'll be worth 20% of the overall score, and on. So for category 2, 25%, and category 3, 20%. So much of it's the same, as well as the budget and the budget worksheet remain at 5%. So it gives you a good sense of when you're completing what has to carry the biggest weight within your application. Okay, this is actually new. Any quantitative or statistical data provided in the program narrative must be verifiable and recorded in official record, meaning that you're putting or you're indicating some statistics. It needs to be coming from either crime rates, or crime reports, arrest rates, recidivism rates. BJA will utilize data reported in that program narrative to determine the applicant's level of need, program capacity, and capability to manage the grant. So again, it's important that you have that verifiable information if you're putting any data or referring to any data within your application. Okay, the budget and budget narrative, the budget, itemized budget for each year of the grant, 25% match is required. Match can be a combination of cash or in-kind. There's no minimum required amount for cash match. Do not report any overmatch in the budget. However, you may discuss the overmatch in the narrative. Applicants should budget to have up to 3 team members attend up to 2 BJA-approved conferences or trainings. And you have the website listed there for if you need to find what those BJA-approved trainings are. And prior approval, planning, and reporting of conference meeting and training costs along in that budget narrative. In your time task plan, again, this is required. Outline goals and objectives. Summarize major activities, have the completion date, expected completion dates, and who's responsible, and the number of participants that will be served quarterly. Within the Memorandum of Understanding and Letter of Support, we want to have key drug court members listed in that. Again, we also included that it can be a designated key staff member that completes that as well. Fiscal agent MOU, state agency, I mentioned most of these documents already. They're a very important part of the application, so I won't keep going over the same thing. Okay. So for the application, some of the things that were mentioned as the top 12 tips to prevent issues that may delay access to funds post-award. So the first one would be the application. The legal name, tax ID, address entered into the SF-424 should be for the legal entity that will be receiving and managing the funds. Please be careful to review and follow the guidance in the solicitation and information to complete the application for federal assistance, which is on page 19. So the SF-424 SAMS registration, when processing awards, OJV and BJA uses SAMS.gov to confirm active registration and verify the legal name, address entered into S14. If the SAMS registration is not active at the time we conduct the search, or if the legal name, address does not match the application, a hold may be placed on funds and the issue will need to be resolved post-award. Number 3, authorized representative. The authorized representative listed in the SF-424 should be the official with authority to sign and accept grant agreements for the legal entity applying for the award. In general, this will be the highest elected official. OJP uses the internet to confirm prior to award. If someone else in your agency has been delegated authority to sign award documents, you should attach that to your application. A letter of delegation on agency letterhead signed by the highest elected official, governing body, which explicitly gives that person authority to sign the award document. The next being total federal funds requested entered in SF-424 should match the total federal request in your application budget for the entire 48 months of the project period. It's very important to make sure the money is a match. For FY17, it is required that you use the budget detailed worksheet template that is linked in the solicitation for your application. If you use a different format, it is possible to receive an award, but you will not be able to access funds until the budget in the proper format is submitted and approved post-award. Unallowable costs within the budget, please do not include any of the costs listed in the allowable use for awards section, page 14. If such costs are identified in your application budget, you will receive an award. You will need to revise the budget before receiving funds. Then subgrants for FY28 budget template has been revised to distinguish between subgrants versus procurement contracts. You should pay careful attention to the guidance on page 24 to properly categorize your cost in this section. Budget match, I mentioned earlier. Refer to the cost sharing or match requirements, cash or in-kind section on page 16. There's 2 notes. 1, all match cost items must meet the same allowability guidelines as federal cost items. And 2, if you exceed the required minimum match amount, any amount over will be required and subject to audit once budget is approved. And application attachments, follow exactly the what an application should include section beginning on page 18. It is very important for reviewers if each applicant is separate, file name numbered as it is in the solicitation. If you combine attachments not recommended, please include a table of contents with page numbers. So the easier you stay consistent with the structure of the application, it makes it that much easier for the reviewers to review the application, which keeps them in a good mood as they're reading it and, puts you in a good position. 10, application attachments. Note this is required for all applications, whether you have duplications to declare or not. See page 29 in solicitation. Please use legal name listed in SF-424, not the drug court or department name in the disclosure language. That's important. If you are proposing to use grant funds to pay an outside evaluator, this attachment is required. See page 30. The attachment must address both 1 and 2. And then program narrative, and I mentioned this maybe already twice, but all projects funded under the BJA drug court have to be able to address the opioid reduction. This should be reflected in the program narrative per the language in the solicitation under each category. So that's definitely something you need to make sure you pay attention while you're doing the application. Okay, and then pretty much lastly, so once you're working and starting to complete your application, we do have some resources listed on the NDCRC website. Some things you'll find on there that I mentioned in the solicitation is the NADCP best practice standards, both volumes. You'll also see the drug court 10 key components, the VTC 10 key components, and the tribal illness to wellness key components, and also included in there for this year examples of some successful applications from last year that's been redacted that you can get a chance to look at to see what we saw were as exemplary applications that wouldn't say necessarily model your applications after, but gives you a sense of what we received and what we viewed as successful applications, along a number of other resources listed on there. The NCDRC website is our website where all resources drug court related, you can find information and also information to share from our other TTA providers or our resources that will hopefully be your resources once awarded funding from NADCP. Their resources are shared on there. Center for Court Innovation, they have resources also in there to learn more about what they're doing, as well as Tribal Law and Policy Institute. And with that, we'll move over to pass back over to you, Preeti, I guess, so we can move forward with questions.
And we have quite a few questions, but I want to first thank you for all the insight on the drug court solicitation. I know it's very helpful to hear directly from you as a BJA representative on some of these key items that are required for the application. And so with that, I will start. We have about 20 minutes, Greg, so we'll go through as many questions as we can, and the rest, if the ones that we don't get to, rest assured we'll make sure we get a response posted on the website under the frequently asked questions file that would be part of the grant resources section that Greg just mentioned. Okay. So the first question, Greg, is it a requirement that we increase the program capacity in order to receive enhancement funding?
It's not a requirement you increase the program capacity. It's whatever. Really, it's whatever, when you're applying for the application, whatever your needs are. If you're applying for an enhancement grant, you have to apply for what's indicated in the application as allowable use of funds. But it's not required that you do have to demonstrate, let me say this, that you are, if you're enhancing, that you are going to be increasing your capacity for your grant.
Okay, great. The next question is related to family dependency courts or family drug courts. And the question is, can they use the grant funds to allow expansion to either add family drug court or just apply directly for family dependency court?
Well, the funding under the Adult Drug Court Discretionary Grant doesn't fund family drug courts. It's primarily for adult drug courts and better treatment courts.
Okay, so it does not, right? Is that what you said?
Does not, exactly.
Okay. The next question is, they applied for SAMHSA grant for a similar amount, and they're asking if it's wise to apply for this one as well.
Yeah, I would apply for both. What generally happens if you do apply for both and you're awarded one or the other, we deconflict applications with SAMHSA. So if you receive one, if we know that you received an award and was awarded, then your application or we both wouldn't award you for the same services. You would be able to apply for both BJA and SAMHSA applications if you focus on a different target population. If you were applying on SAMHSA for a veteran treatment court or a co-occurring court and you were applying or BJA under the opposite, you could do that, but you couldn't be the same. If you were applying for both the same, we would deconflict that depending on who awarded first.
Okay, thank you. The next question is, can they write one application to provide funding for two different courts, such as if they have a drug court and a veterans treatment court, or should they submit two separate applications? And on a related note, another question was, can they submit two proposals at all? Like, is it allowed to submit two proposals?
Yeah, you can submit two proposals again, like what I mentioned earlier, related to that first note in the presentation, that you can apply. One court can apply for two BJA adult drug court grants. Again, the only difference is they have to have different target populations or area of focus. So it can be done. Yeah, so you can do that.
Okay, but can they apply? Can two drug court and a veteran treatment court write one application together?
Yes.
Okay. So
yeah,
yes.
And I think I'm trying to remember what you asked me first too. You were asking if one court wanted to apply for both a veteran treatment court and, let's say, a co-occurring court, they would be able to do that as well.
Perfect. Okay, thank you. All right. There's another question about past funding announcement. It said, past funding announcements have indicated a threshold date by which drug court services must commence. Is there a similar date associated with this announcement for those applying for implementation grants?
I don't recall a threshold date that you had to start. So this grant, as you can tell, if many of you are familiar with BJA grants, know they have started in October this year. We're starting in January. We do understand at times when you're receiving these grants that there may be startup challenges. So when you're awarded, you will be working directly with your program manager to help you address any lag time in your application. So I don't know, we don't necessarily have any listed thresholds for the starting. The start date will be January 29th, and once you're awarded.
Right. This is for the implementation grant, so they would be in the planning phase. So the question is related to starting the drug court services itself.
Yeah, I know the planning stage. One of the things I mentioned earlier was the BJA drug court planning initiative, which is a training that you would have probably needed to participate in or in before the application process, for that to be a prior consideration. For the implementation grant, let me look at that again. I don't believe we have anything in there that indicates that there's a time frame for getting started outside of the actual start date.
Okay, great. Thank you. The next question is, can funding be used to assist with transportation needs for those in rural settings?
Transportation, it would be, so that's what I want to be careful of. So with the challenges, rural populations and providing services in rural population is a priority for the administration and the services that we provide through our drug court program. So it would be allowable, but you have to use your discretion in terms of what you're asking for in your award. Again, it goes back to we want to make sure the services are closely connected to criminal justice services and treatment services, and that they completely tie in with the goals and objectives. So when you're completing the application, if that's something you're looking to include in the application, again, make sure that it's completely tied to the goals and objectives, and that it's you're not spending 50% of the budget for travel. and making sure that you're addressing that.
Sounds good. And then would you recommend that they review the financial guide on any sort of transportation guidelines?
Yes.
Okay.
Yes, it would.
Okay, great. The next question is with regards to fiscal agent MOU. The question is, if the state judiciary will be awarded the grant and they will distribute some of the funds to the State Department of Corrections, do they still need a fiscal agent MOU given they're both state agencies?
Yeah, that's one thing I mentioned earlier. So that really pertains more so to local government and county agencies.
Okay. Well, so would you recommend they get a letter of support, perhaps?
Yeah.
Not an MOU? Okay.
Yeah, that didn't change. Yeah, they will still have to get a letter of support.
Okay. Okay. Next question is similar to the fiscal agent question. The question after that, can court administration be the fiscal host or State Department of Corrections? That sounds like the same question, I guess. So the next question is, if we are to fund for 48 months, what is the max amount we can request?
Up to, depending on the category, up to, so for implementation or enhancement, up to $500,000.
Okay. Can a nonprofit agency that operates a drug court be the fiscal agent?
No, they have to be what we have listed as eligible. For those who are listed under eligibility, it has to be what we talked about in terms of it has to be state agencies, local courts, counties, units of local government. It wouldn't be nonprofits, no.
Okay. The next question is, under Category 2, can you apply for an enhancement that reaches across several of your drug court programs? For instance, we want to add recovery services to our drug court program, DUI court, and Veterans Court.
Yes.
Okay, great. Can this funding be used to supplant existing state and local funding?
No.
Right. The next question is, we currently have a BJA implementation grant set to expire December 2019 for an adult drug court. Can we apply for an enhancement grant this year?
No, if you're currently receiving, is it the same focus? I must have missed that last part.
It's the BJA implementation grant that expires next year, next December.
The answer is two answers to that. The one, no, if the implementation grant they currently have has the same focus and target population as the one they would be applying for an enhancement. Because it sounds like they would be having, it said it ends December 2019. Well, this one will be starting in January 2019. So that would be, they would be applying for two active grants. And although one is implementation and one is enhancement, they can't be, if they both have the same target population, then they wouldn't be able to do that.
Right, and if I remember correctly, they have to disclose what current funding they have in a separate form and then explain, I guess, how this would be different.
Correct, yeah, you're correct.
Okay, great. Next question, can we charge clients a participation fee in an effort to provide them with incentive awards?
Can you charge clients
participation fee in an effort to provide them with incentive awards?
Let me get back on that. I don't, you can, as a drug court, charge a fee for services, but let me hold back on that one.
Okay, I'll put you.
Yeah.
Okay, let's see. The next question is on page 21, section 3, the program narrative, bullet point C, capabilities and competencies. What is BJA actually looking for here?
What page? I'm sorry.
21, the capabilities and competencies section.
Okay, capabilities and competencies, that has a lot to do with who's going to be operating the drug court program. You have to indicate in there, I mean, it's sure can be kind of spelled out in solicitation, but it's also who you plan on having as staff within your drug court program, supplying their credentials, their years of experience, and how would they be able to or demonstrate your capacity to be able to facilitate the grant award once you receive the funding. We want to make sure that you can demonstrate that you can actually facilitate the grant, and by doing that, you want to indicate what trainings that your staff has had in the past, what are some of your current funding, some of your current staff. So that's more about how you would be able to facilitate the grant.
Okay, great. The next question is, can this funding be used to create a new data management system for the state treatment court?
Yes.
Okay.
And I want to go back to the other one, for the capability and capacity. Also, again, to get off some good examples, please go back or get a chance to go into the NDCRC website and look at some of the successful program narratives that give you ideas of what's been put in there in the past.
The next question is, can they use the $500,000 in less than 48 months?
Yes, yes.
Okay. And then how do you define urbanicity?
I'm sorry, you broke up.
How do you define, I'm having a hard time saying this word, urbanicity, yeah, urban city, I guess.
Yeah.
Like an urban city.
Oh, how do you define urban? Well, I don't know if we have a particular definition of what we should have a definition of urban. What I'll do is I want to make sure I'm clear in terms of, so when you're applying, so you know and be able to identify whether you're urban, rural, or suburban city, we'll also have that that question identified, so that everyone can have like more of a consistent BJA definition of that.
Okay, great. The next question is page 4 of the solicitation. I'll give you a chance to turn to page 4, but it's second to last paragraph notes exclusion of violent drug offenders who sold drugs for profit. Does the selling drugs for profit apply to criminal history as an offense before the court, or both?
Okay, can you read that again? I'm sorry.
Yeah, so page 4 of the solicitation, second to last paragraph notes exclusion for violent drug offenders who sold drugs for profit. Does the selling drugs for profit apply to criminal history, offense before the court, or both?
Both.
Okay. Okay, and then it says, page 14 states that award funds cannot be used.
And Preeti, real quick, I just going back to some of the questions related to whether it's capabilities or other sections of the application. It's important to go to section, just want to make sure I'm clear, go to section E of the application where you have each of the categories broken down and pretty much defining what should be in each of those categories. So if you're applying for implementation, it lets you know what you need to have in each of those sections. Okay.
Okay. The next question is pertaining to incentives. Again, it says page 14 states that award funds cannot be used to purchase various prizes. unless associated with approved program activities, can these type of items be purchased if used as incentives?
So can they be used as
right, as incentives?
Yes. Well, award funds may not be used for prizes, rewards, entertainment, trinkets.
Okay.
Support approved. Any costs that do not support the program. So it's like we're saying is if it's consistent with the programs and support the program, that it would be able to be used for incentives.
Okay. So we have like maybe 10 or 12 more questions, and I know we're up against the hour.
Yeah.
Maybe we'll do one more because this was submitted through an email from Angie Plunkett in Missouri. They have a state holiday, so she asked if we could ask this question.
Okay.
And it's, she said, the solicitation mentions MOUs, but if a state is submitting an application under 3B, are letters of support from the local program needed or recommended?
No, again, that only applies to local entities and local government county entities, and not to the state who would be applying.
Oh, okay, so local programs do not need, it's not needed or recommended?
No, because if they're applying for B, then the state would be having oversight. The state would be the fiscal agent, but they would also be having, through the statewide grant, having authority over the drug court that they would be providing funding to.
Okay, so we don't need the letter of support from local programs.
Oh, I'm sorry. I thought you were talking about the MOU. Yeah, they would need a letter of support, yes. I'm sorry, I got another form confused what you're talking about.
Okay, so they would need it?
Yes.
All right, I think, so we do have some more questions, but as we mentioned earlier, we're going to both the questions we went over just now and also the additional questions that are coming in. And if you have, any follow-ups, please